By the summer of 2024, OpenAI's valuation had crossed $100 billion. Its non-profit parent entity, the structure that was supposed to hold the commercial operation accountable to a public mission, controlled a shrinking share of that value with every new funding round. Elon Musk had been watching this from the outside for 6 years. When he finally broke his silence in a way that carried legal weight, the question the industry could not stop asking was simple. Was he wrong? OpenAI was never loved. Nobody had a poster of the GPT-3 research paper on their wall. Nobody felt nostalgic about a chatbot interface, but OpenAI had something more durable than affection. It had a structure that made trust feel rational. When the organization was founded in December 2015, the founding commitment was explicit and unusual. A group of researchers and technologists, Elon Musk and Sam Altman among the most prominent, pledged roughly $1 billion toward building artificial general intelligence in a way that was transparent, collaborative, and accountable to humanity rather than to shareholders. The nonprofit structure was not incidental, it was the entire argument. The claim was that the incentives of a commercial company would inevitably corrupt the development of technology this consequential, and that a different legal structure could produce a different outcome. People found this persuasive because it was designed to be verifiable. You could look at the governance documents, you could read the research papers because OpenAI published them. You could see that no single investor held controlling interest over the organization's direction. Musk's role in those early years was not ceremonial. He was a co-founder, an early funder, and publicly one of the most vocal advocates for taking AI safety seriously at a moment when most of the technology industry was not. His fear, stated plainly in interviews from that period, was that a small number of companies building AGI for profit represented an existential concentration of power. The founding of OpenAI was his proposed solution to that problem. Build the thing openly under non-profit governance before someone else builds it behind closed doors. Altman's role was different but equally essential. He was the operator, the person who understood how to actually assemble an organization, raise money, recruit researchers, and ship products. Where Musk supplied the ideological urgency, Altman supplied the institutional competence. Together, and with researchers like Ilya Sutskever, who joined from Google Brain, they built something that the AI research community took seriously almost immediately. That credibility was structural. It came from the nonprofit status, from the open publication of research, from the explicit rejection of the profit motive as a governing principle. OpenAI did not earn trust through passion. It earned trust through design, and that is exactly what makes what happened to that design so significant. That structure was the entire point, and it did not survive contact with the money. Elon Musk left OpenAI's board in February 2018. The official explanation was a conflict of interest. Tesla was developing its own AI systems for autonomous driving, and Musk's dual position created an awkward overlap. That explanation was true as far as it went. What it did not explain was why Musk, in the years that followed, described his departure in entirely different terms, as a disagreement over direction, over who would control the organization, over whether the original mission was already being quietly abandoned. Two explanations for the same event. One tidy and procedural, one structural and uncomfortable. The gap between them is where this story actually lives. The more consequential change came in 2019. OpenAI restructured itself into what it called a capped profit model. The design was presented as a pragmatic solution to a real problem. Building AGI requires enormous computational resources, and non-profit fundraising cannot generate the capital that requires. The new structure created a for-profit subsidiary that could accept investment. Returns to investors would be capped, initially at 100 times their investment, after which any additional value would flow to the non-profit parent. On paper, the mission remained intact. The non-profit still held ultimate authority. The language of safety and public benefit remained unchanged in every public statement OpenAI made. This was not a funding mechanism. It was a governance transfer, dressed in the vocabulary of mission preservation. The first sign of what that transfer meant arrived almost immediately. In 2019, Microsoft invested $1 billion in the new for-profit subsidiary. That investment did not simply provide capital. It embedded a commercial partner with its own product roadmap, its own cloud infrastructure business, and its own competitive interests directly into OpenAI's operating structure. Microsoft needed OpenAI to succeed commercially because OpenAI's success was now tied to Microsoft's Azure platform. The incentives of a technology conglomerate with quarterly earnings calls were now structurally present inside an organization that had been founded on the premise that commercial incentives corrupt AI development. People accepted this because the vocabulary did not change. OpenAI still published the safety framing. Sam Altman still gave interviews about existential risk. The stated mission, AG for the benefit of humanity, remained on the website, in the press releases, in the congressional testimony. The structure beneath that language had shifted in ways that were real but not immediately legible to anyone who was not looking carefully. And for a few years, the gap between the language and the reality stayed small enough that nobody had to choose which one to believe. On February 29, 2024, Elon Musk filed suit against OpenAI Inc., the OpenAI Foundation, Sam Altman, and Greg Brockman in the Superior Court of California, San Francisco County. The core allegations were breach of contract, breach of fiduciary duty, and unfair business practices under California law. The complaint was specific about what had been agreed to and specific about what had changed. Musk argued that he had contributed time, money, and credibility to OpenAI on the basis of a founding agreement, that the organization would develop AGI openly for humanity's benefit under non-profit governance. That agreement, the lawsuit alleged, no longer described the organization that actually existed. What Musk was asking the court to decide had nothing to do with whether he liked Sam Altman. The legal question was narrower and more consequential than the media coverage suggested, not whether AI development should be open or closed, not whether Musk was a credible critic of an organization he had left 6 years earlier. The question was whether a specific legal agreement had been honored and whether the people who signed it had fiduciary obligations that they had subsequently violated. Courts do not adjudicate AI ethics, they rule on contracts and duties. And the contractual framing of this particular complaint meant that OpenAI could not respond by pointing to its research output or its safety commitments. It had to explain what happened to the governance structure it had originally promised. OpenAI's public response was swift and consistent in its framing. Altman characterized the lawsuit as driven by personal grievance and competitive self-interest. OpenAI's legal team filed a motion to dismiss. The organization published a blog post that argued Musk had been fully informed of and had supported the 2019 restructuring while it was happening. They released emails they said demonstrated his involvement in discussions about the for-profit transition. The message was clear: this is a disgruntled former co-founder, not a principled whistleblower. That framing may or may not be accurate. What it did not address was the legal question itself. And in August 2024, when Musk filed an amended complaint with additional allegations tied directly to OpenAI's accelerating timeline toward full-for-profit conversion, the personal grievance dismissal became harder to sustain. New defendants were named. New evidence of internal decision-making was introduced. The amended filing arrived at a specific moment. OpenAI was in active discussions about restructuring enhanced profit into a public benefit corporation, a move that would effectively remove the nonprofit's controlling stake in the for-profit subsidiary entirely. For the first time, someone with legal standing was forcing this question into a room where it had to be formally answered. The psychology of that moment matters. People accept organizations changing. What they reject is discovering that the organization they trusted had been changing in ways they were not told about, under a vocabulary that stayed carefully constant while the underlying structure shifted. Musk's lawsuit did not create that feeling. It gave it a legal address. The lawsuit did not appear from nowhere. It was the visible surface of something that had been accumulating for years, one decision at a time, each individually defensible, collectively impossible to ignore. In November 2022, OpenAI launched ChatGPT. The public framing was a research preview, a tool released to gather feedback and observe real-world behavior. Within 2 months, it had reached 100 million users, a growth rate no consumer application had ever matched. It was not a research preview. It was a product launch, and one of the most successful in the history of the technology industry. The nonprofit's research arm had become, functionally, a consumer technology company overnight. The vocabulary did not change, the reality had. In January 2023, Microsoft announced a new multi-year, multi-billion-dollar investment in OpenAI, ultimately reported at more than $10 billion. The Azure cloud platform would become OpenAI's exclusive provider. OpenAI's models would be integrated into Microsoft's entire product suite: Office, Bing, GitHub Copilot, Azure's enterprise offerings. The relationship was no longer that of a funder and a mission-driven grantee. It was a deep commercial partnership in which each party's financial success depended directly on the others. The nonprofit's for-profit subsidiary was now structurally inseparable from one of the largest technology companies on Earth. Then came the decision that was hardest to explain away. When GPT-4 was released in March 2023, OpenAI did not publish a technical paper describing how it was built. The organization that had put the word open in its name, that had founded its credibility on transparent, peer-reviewable research, declined to share the technical details of its most capable model. The stated reason was safety and competitive sensitivity. The practical effect was that OpenAI's research was now a proprietary asset, protected like any other commercial trade secret, open in name, closed in practice. November 2023 produced the crisis that made these decisions impossible to ignore. The board of the nonprofit parent, the body that was legally supposed to hold the commercial operation accountable to the founding mission, fired Sam Altman. The stated reason was a loss of confidence in his candor. Within 5 days, under pressure from Microsoft and from OpenAI employees who threatened mass resignation, Altman was reinstated. The board members who had voted to remove him were replaced. The nonprofit's governing body, the only structural check on the commercial subsidiary's direction, had attempted to exercise its authority and been functionally overruled by the weight of commercial interest. Each of these things alone had an explanation. Together they formed a pattern. OpenAI was no longer a safety-first nonprofit that happened to have commercial products. It was a commercial AI company that happened to still use the vocabulary of safety. The mission language remained. The governance structure that was supposed to enforce it had been hollowed out, not by a single dramatic decision, but by the accumulated pressure of money, scale, and competitive necessity. And Musk had watched all of it from the outside. Musk did not leave and go quiet. He built something. xAI was incorporated in July 2023, 4 months before the OpenAI board crisis, and roughly 18 months after Musk had begun publicly criticizing the direction of AI development at the major labs. The stated mission was deliberately broad, to understand the true nature of the universe, a formulation that is either philosophically serious or strategically vague, depending on how charitably you read it. What was not vague was the timing, the funding, and the specific design decisions that followed. The first version of Grok, xAI's language model, launched in November 2023 through the X platform. The feature that distinguished it from ChatGPT most concretely was real-time data access. Where ChatGPT's knowledge had a training cutoff, Grok could pull from the live feed of X hundreds of millions of posts per day, updated continuously. For users who wanted current information rather than a model's best recollection of events that ended months ago, that was a functionally meaningful difference, not a marketing claim. The structural design of xAI is worth examining without enthusiasm and without dismissal. Musk owns X, the platform that generates the training data. He owns xAI, the company that trains the model on that data. He controls the distribution channel through which the model reaches users. This is a degree of vertical integration that OpenAI, even with its Microsoft partnership, does not have. No board can fire Musk from AI the way OpenAI's board attempted to remove Altman. No single investor holds leverage over the organization's direction. The concentration of control is absolute and transparent, which is a different thing from being reassuring. The tension is the honest version of the XAI story. The alternative to a set of powerful institutions controlling AI development is not some neutral distributed commons. It is in this case one person with no institutional check on his decisions whatsoever. Whether that is better or worse than OpenAI's current structure is a question the evidence does not answer cleanly. It is a question about which kind of concentration of power you find less alarming, and reasonable people arrive at different places. What XAI's existence does change, regardless of how you answer that question, is the competitive and rhetorical landscape. OpenAI could no longer be positioned as the only serious alternative to closed commercial AI development at Google and Meta. A new variable was in the room, and the lawsuit Musk had filed meant that the new variable came with a public argument about what the rules were supposed to be. This is where the story gets genuinely consequential, not in the personal drama between two men, but in what the lawsuit has already forced into the open, regardless of how any court eventually rules. In the months following the February 2024 filing, OpenAI's planned conversion to a fully for-profit public benefit corporation became a matter of public record and public pressure in ways it had not been before. California's Attorney General opened a review of OpenAI's obligations under a not-for-profit charter, a direct institutional consequence of the legal framing Musk's complaint had introduced. The question of whether a non-profit can simply transfer its controlling stake to a for-profit entity without regulatory scrutiny, which had previously been treated as an internal governance matter, was now being examined by a state official with actual authority over the answer. That did not happen spontaneously. It happened because a lawsuit put the legal vocabulary in the room. The discovery process produced something else. Internal communications surfaced during litigation showed the gap between OpenAI's public safety framing and its internal decision-making calculus in ways that were difficult to explain away. Discussions about the GPT-4 technical paper, about the pace of deployment versus safety evaluation, about the board's authority relative to the commercial subsidiary's operational decisions. These were no longer things OpenAI's leadership could describe in their own terms, on their own timeline, through their own press releases. They were now part of a legal record. The mission was never the problem. The governance structure, consuming it from the inside, was the problem. Force that into the open, and the mission can breathe again. What this means practically is that the lawsuit's value was never primarily about its outcome. Musk may win, lose, or settle. The amended complaint may be dismissed in part or in full. None of that changes the fact that a specific set of questions about fiduciary duty, about what nonprofit governance actually requires, about the legal enforceability of a founding mission, are now being examined in a forum that does not accept press releases as evidence. That exposure already happened. It cannot be undone by a stronger safety statement or a more carefully worded blog post. The lawsuit did not register in the forums and Slack channels where this actually matters. What registered there was something quieter and more personal. It's a slow realization spreading through communities of developers, educators, and small organizations that a tool they had built their work around was now governed by incentives they had never agreed to. Consider the independent developer who spent 6 months in 2022 building a product on the OpenAI API, a small application for a specific professional workflow priced carefully to be sustainable at OpenAI's then current access costs. By 2023, pricing structures had changed, access tiers had been reorganized, and the terms governing what could be built and how had shifted on OpenAI's schedule, not the developers. The work remained, the assumptions it was built on did not. Developer forums throughout that period filled with posts from people describing not anger exactly, but a specific kind of disorientation, the feeling of having built something on ground that turned out to be owned by someone else. Consider the non-profit education organization that adopted ChatGPT in early 2023 under the reasonable assumption that a tool created by a non-profit safety research lab was a reasonable fit for a mission-driven institution. By mid-2024, that organization's vendor was a commercial entity in active negotiations to remove its non-profit governance structure entirely, with quarterly earnings pressure and a Microsoft partnership that shaped every product decision. The tool had not changed noticeably. The nature of the relationship had. Word of mouth among these communities is something the tech industry consistently underestimates. When a curriculum director tells her counterparts at other institutions that the AI tool she integrated into her classroom is now behaving like a subscription product managed for retention, rather than a research utility managed for accuracy, that observation travels. It does not travel through press coverage. It travels through the professional networks where people who do actual work compare notes about the tools they depend on. The Musk lawsuit gave language to a feeling many of these users already had, not the personal grievance framing. Most developers and educators had no particular view on Elon Musk. The structural framing. The argument that the organization's governing promises and its actual operating reality had separated in ways that were now legally visible and publicly documented. That framing arrived in communities that were already asking the same question in less precise terms. The people affected are already adjusting. The question is whether the institution causing the adjustment can. OpenAI's leadership is reading this situation as a legal problem. A compliance gap that can be closed with restructuring, with better documentation of board procedures, with a public benefit corporation designation that preserves the safety language while removing the governance constraints that were supposed to enforce it. It is not a legal problem. The monetization architecture is the problem, and it is not separable from the organization itself. Microsoft's multi-billion-dollar investment is embedded in OpenAI's operating structure in ways that make genuine independence from commercial pressure functionally impossible. The revenue that funds the research comes from the products. The products require the cloud infrastructure. The cloud infrastructure is Microsoft's. Remove any piece of that and the organization that remains cannot build what it is trying to build. This is not a design flaw that escaped notice. It is the design. And the non-profit governance layer that was supposed to sit above all of it and enforce the founding mission has demonstrated, in November 2023 with the board crisis, that it does not have the weight to hold against that commercial structure when the two come into direct conflict. OpenAI's response to the lawsuit has followed a predictable pattern: more safety language, a new safety committee, statements about responsible deployment and frontier model risk. Each of these things is real in the sense that people are assigned to work on them. None of them address the structural question the lawsuit is actually asking, which is whether the organization's legal obligations to its founding mission can be enforced against its commercial operating reality. Adding safety vocabulary to a structure people now understand to be commercially captured does not restore trust. It deepens suspicion. The broader industry is already reading the situation differently than it did 2 years ago. Regulators in California and in Brussels have both signaled that the governance of frontier AI development is a question of public interest, not just corporate policy. Hardware manufacturers and enterprise customers who built procurement decisions around OpenAI's nonprofit framing are now conducting the kind of due diligence they did not think was necessary in 2022. The question of what an AI lab's governing promises actually mean and whether those promises are enforceable is now on the table in rooms where it was not before. Musk will not win or lose this story in a San Francisco courtroom. He has already won the more consequential thing. The question is now impossible to avoid. The gap between what OpenAI said it was and what it actually became is no longer something that can be managed through careful public communication. It is in the legal record. It is in the regulatory review. It is in the professional networks of everyone who built something on the assumption that the original contract would hold. When the gap between what an institution says it is and what it actually is P becomes legally visible, can more features close it? Drop your thoughts in the comments.